And we should be live.
Good morning, Mark. Welcome back.
Good morning. Thank
For the
you
year.
for remembering me. Yes.
Uh,
Just for the members of the committee, my name is Mark Langen. I'm a tax attorney focusing in the area of estate and gifts and taxation and income taxation as it relates to fiduciaries. And I serve as the chairman of the probate and trust section of the Vermont Bar Association. I'm currently in a hotel room down in Boston. I escaped the storm yesterday. It was pretty rainy, but and I'm coming back on Friday, so I hope I can get back on Friday. Anyway, the these two acts were put together by a joint committee of the probate and trust section of the Bar Association and the trust committee of the Vermont Bankers Association. So in the past, back in 2009, those two committees got together and put together the Uniform Trust Code. And so we have and that's important to know because we had that in mind as we worked through these two statutes. They're somewhat related. I mean, it's Uniform Acts. One is called the UDTA and the other is the UTBA. So I think that it's best to try to walk you through the Directed Trust Act first because it informs some of the understanding of the Trust Decanting Act. And also, I spoke to Ben at the break, and I'll try to keep my comments to end at 11:15 so that you're back on track as far as time goes. So in the Uniform Directed Trust Act, what is happening there is that a lot of trusts now have found that they're drafted in a way such that the fiduciary powers of the trustee may be allocated to a person who is not the trustee. Sometimes they're referred to as the trust protector. Sometimes they have numbered trust advisor. But for purposes of the act, they're referred to as a trust director. And basically, the trust director can direct the trustee to do things that the trust director has been granted the power under the instrument to do certain things. Let me give you some concrete examples of where we see that. You may have, let's say, a corporate trustee who is far away from the beneficiaries, and therefore you need to have someone who has more of a boots on the ground, can tell how are the beneficiaries doing? Do they need medical care? Do they need education? What do they need? What do they need for their job? That sort of thing. So sometimes you want to bifurcate and say, hey, corporate trustee down in Burlington or whatever, you're going to do the investments, decide what to buy, what to sell, and stuff like that. But the trustee, we're going to have a trust director who is watching the beneficiaries, and they'll tell you what they need. And that trust director can say, hey, spend money on this, spend money on that sort of thing. There was another example that I had, which was where husband and wife had reciprocal trusts, and they were trustees of their own trust. And husband died, and so wife became the trustee of husband's trust. She was the sole beneficiary. But in order for it to bypass her estate, she could only distribute principal to herself that was within what we call the ascertainable standard, i.e., health, education, maintenance, and support. She had about 2.5 million in her trust. He had about 2.5 million in his trust. And what they wanted to do was to move his trust to her trust so that when she died, and she was about 98, she would get a second step up in basis for income tax purposes. And she couldn't do that. She was 98, couldn't exercise the power. And that's where a trust director would have come in handy to say, hey, I'm going to exercise the power and allow you trustee, to distribute the assets to her trust, because even though it wasn't really for her support, I'm going to allow it. And we did that with the consent of children. It also, we use trust directors where, let's say, the parent wants to set aside money for a trust for their children. But if they become the trustee and can decide when and how much those kids get to use it, it's includable in their estate. It's not a completed gift. That's where a trust director comes in handy, where they could say, okay, as parent, I'm going to talk to the broker, tell them what to buy, what to sell, I'm going to manage the trust, but I'm going to appoint a trust director to decide what distributions I can make and when to or for the benefit of my children. And then probably the area that the trust director has become really important is in the area of where the settlor has a high concentration of stock in one company. Let's say you're Bill Gates and you have a lot of Microsoft stock. If you have a corporate trustee, if you put some of that stock in with a corporate trustee, the first thing they want to do is diversify the portfolio. That's the mantra of modern portfolio theory. So sometimes people who did that say, no, I don't want to do that. So I'm gonna get that corporate trustee off the hook for keeping it in concentrated and give it to a trust director, and the trust director will tell them what they could do. So those are some examples of where we've been using trust directors. The UDTA applies trust law to the persons who are delegated as the trust. So what's going on here is that if you have a trust director, to the extent that trust director has a power, that power is subject to the fiduciary duties and obligations under the Uniform Trust Code. So, but only to the extent of the power that was granted to them, and vice versa. If, let's say, the investment power is taken away from the nominal trustee, or excuse me, not the investment power, but let's say the distribution power, then they're off the hook. They can be held liable for the powers that they don't have, which have been changed. They notice that also, instead of the formal situation where you may have a trustee and then you call them a trust director, a parallel situation can be going on with co-trustees, where you appoint co-trustees, they're trustees of the whole trust. But if you start to delineate and say, okay, trustee A, you're the boots on the ground person, so you're gonna tell trustee B when to make the distributions. So even where the nominal change is just co-trustees, this act can apply to that. And so what it does is, what's going on right now, people are creating trust protectors, trust advisors, directed trusts. And what this statute does is give some framework, some guardrails, some guidance as to how to act as a directed trust. So, and then they've dealt with some specific issues like succession and co-trusteeship, and there's a careful system of exclusions with respect to tax planning, revocable trust, and powers of appointment. So with that said, I'd like to sort of walk you through, just give you a walk through the statute. And I'll begin with sections 1301 and 1302 are just the name of the act and the definitions. So I'm going to start with 1303, called application. And this is sort of interesting. What it will do is it will apply to trusts that exist before the effective date of the act, but only with respect to actions taken after the effective date of the act.
Can I interrupt you, Mark?
Yeah.
Or Mr. Lincoln, real quick? Did you say 1303 or 1404?
I think the version that I had of the trust directing, I think, was 1303, and 14 is the Trust Decanting Act.
Okay. I just want to make sure we're all looking at the same thing. The bill that we have in front of us is as
We were
passed by
scheduled to do the Uniform Trust Decanting Act first.
Okay, yeah, and that's why I said I prefer if I could do the directed trust act because it informs understanding of the
Okay.
Decanting Act.
Well, we have the agenda messed up. If you
Okay.
look at the agenda, we have the Decanting Act going first.
Okay.
Yeah, sorry, that was my fault. I didn't realize there was an order to it. So just
Okay,
do a
so
quick
you're
swap.
the Uniform Directed Trust Act. Thank you, Senator Epstein.
Taking the second one
On H
first.
350 then. Okay.
There we go. We're on H 350.
Okay.
I
So,
thought H 279.
uh-huh. And so, okay.
So everything you said about the Uniform Directed Trust Act is not we've got. So now we're going into the Uniform Trust Act,
Directed trust act, yeah.
Directed Trust.
Okay. And then 1303 goes on to say that if a trust decants into Vermont, they'll be subject to the act. 1304, a lot of these is a very common provision in Uniform Acts that says that the statute does not crowd out the common law. Common law principles of equity still stay in place. 1305 says it does not apply to a settlor's power to revoke or a beneficiary's power of appointment. So those are two powers, the power to revoke that usually the settlor retains and the power of appointment where the power of appointment is where the beneficiary may say, beneficiary is the beneficiary, let's say for life, but could decide who gets their share of the trust after they die. That's a power of appointment. And the fact that the beneficiary has a power of appointment doesn't mean that they are a trust director and they have all the fiduciary duties. So it's just doing some clarification there. In 1306, a trust, this is the I would say the effective provision that says that the trust may grant powers to a trust director, and the trust director may appropriately exercise those powers. And if there's one or more trust director, they have to vote by majority. It's silent as to when you have two, but I think majority means you would have to have unanimity about by two. In 1306, a trust may grant powers to a trust director, and the trust director may appropriately exercise. Oh, excuse me. I already did 1306. 1307. The trust director is subject to the same, like a trustee, the same obligations in particular with regard to two powers, which is making sure that if there's a special needs trust, that they comply with the Medicaid payback provisions. And if there are charitable, that their charities are very protected under these acts so that their interests are not diminished. And if the charity is for a general public, then we usually get the AG's office involved to represent the interests of the general public. 1308 and 1309, there are reciprocal provisions in which they enumerate the duties and liabilities of the trust. Yes. I'll break for a question.
Yeah, I just had a quick question. So you said that if the charity is related to the general public, you generally get the AGO's office. Is that in statute or just by practice?
It's generally by practice.
Okay.
I don't know that, let's say New Hampshire has actually in the AG's office a director of charitable trusts. I guess it keeps them busy, a full-time job. My understanding is the AG's office delegates one of the deputy attorney generals to take the role of like a director of charitable trust to represent the general public. So let's say you had a trust which was for the benefits of the citizens of Montpelier, basically the AG basically stands in their shoes to represent their interests.
Okay. Thanks.
Okay. You're welcome.
Okay.
So 08 and 09 deal with the liability and the duties. And basically, to enumerate the general fiduciary duties of a trustee are: number one, to follow the trust. This is from the Vermont Trust Code, Section 801. Follow the trust and carry out the best interests of the beneficial interest. Two, there's a duty of loyalty. It's very specific. It means that the trustee cannot engage in activity which would be economically competitive with the trust. And three, the duty of partiality, meaning that you cannot treat beneficiaries with partiality. You must be impartial. So those are imposed on trust directors as well as the trustee, and so they're reciprocal with each other. Because of this bifurcation or change or of that, they felt it was necessary that in section 310 and 311, those sections kind of go together, and they say that, hey, trustee and trust director, you need to communicate with one another, and here are the rules about communication. However, in 311, they say you don't have a duty to monitor and make sure that the other person is doing their job correctly. So this is a big issue. Let's say that what you do is you give the trust director the power to remove and replace the trustee, and you have a trustee who's been doing bad stuff. Well, the trust director basically, in a sense, does the liability extend to the trust director because it happened under the trust director's watch? Generally, no. What the Act makes clear is saying that the trust director really has no liability if they are unaware of this and they have not been requested by any of the beneficiaries or any other person to remove the trustee. That's probably a very tricky power, that removal and replace of a trustee, because you could say you could hold them liable for everything the first trustee is doing. But mostly a lot of the powers that are given to the trustee are not that, but they might be to, let's say, just fill a vacancy if there was a vacancy of trust. So that's very helpful. I just did a trust recently where my clients kind of ran out of who they wanted to be successor trustees. And they had a person who they thought would be good at naming a trustee, but they didn't want to burden that person with being the trustee. So they gave somebody a power to do that. Moving on to 312, that's the section that sort of delineates and qualifies where you've divided the powers and obligations among co-trustees. So it's a section for co-trustees saying, hey, you co-trustees, you have separate powers to do, so you're kind of like directed trustees. One of you you're both like directed trustees. So we're going to allocate fiduciary duty and liability to you, but only with respect to those powers that you have. 313 has to do, it basically says that the statute of limitations to sue a trustee in the Uniform Trust Code applies to the trustee, obviously, but it also will apply to the trust director. So the trust director is given some ability to not have lingering liability for years and years and years after a trust terminates.
What is the statute of limitations?
Yes. Generally, I'll tell you what we usually do in the practice is that when a trustee is going to wrap up a trust, they'll try to get consents from all the beneficiaries with what we call a receipt and release. Hey, we'll give you the money provided you release us from liability for any claim you had or may have in the future. And then you'll get your money. So it ties it up very nicely. If the trustee is unable to procure all the consents, like I have a case right now where it's clear that one of the beneficiaries is clearly off her rocker and just wouldn't understand it, then the trustee usually goes to court, files the accounting, and it gives the beneficiaries get notice of the accounting, and they get a copy of the accounting. And if they want to object, they can. However, if they don't, then when it comes to hearing time, once the judge grants it and allows it, the trustee is then released from liability. So that's the two venues or the two paths that they can take, getting the consent of the beneficiaries or going to court and getting the imprimatur of the court. 1314 is the trust director may assist in all defenses of a trustee. So any defense that's given to a trustee is also afforded to the trust director. 1315, basically, it has to do with jurisdiction over a trust director. So it's sometimes a little bit unclear as to when does a trustee or a successor trustee become a successor trustee or even a trustee, original trustee. And so obviously if they sign a document saying, okay, I hereby accept the trusteeship, okay, they've accepted at that point. But sometimes things aren't that clean. And so the Uniform Trust Code says, hey, you become the trustee when you start to act like a trustee, when you take an action that is like a trustee. And the same would apply to a trust director. And 1316 says there are certain rules that applies to trustees and they'll apply to trust directors as well, such as acceptance, giving a bond, reasonable compensation, resignation, removal, and vacancy. So that's all laid out so that there's rules for the road for the trust director. And then the last two sections, 1317, is basically, to the extent possible, consideration should be given to interpreting this statute in uniformity with other statutes. So many states have passed the Uniform Directed Trust Act, and therefore, if there are court cases interpreting the act, that helps us. Am I breaking up?
In the State House. We don't, can you hear us?
Text Ben.
Yeah. Text Ben.
Yeah, they won't.
You're muted, Ben.
They won't be able to hear anything.
No, we can hear you now.
Ben,
We
you're
can't
muted.
see you, but we can hear you.
Oh, you can hear us?
Yes.
There you go. We've lost electricity in the State House.
Oh,
Oh.
wow.